On the 24th September, the country was ground to a halt after the long-awaited white paper was released from State House. Many were knocked sideways with this development, while others were on the edge of their seats awaiting the publication. My name is Mohamed Jallo. Permit me to walk you through how it all started and the pathway this latest development might lead us as a country. The government paper and how it all started. Now, the objective of this lesson is to explain the legal basis for the formation of the Commission of Inquiry, a brief account of the history behind it and why the government white paper. To also look at other legal avenues open to persons named and implicated in the government white paper. Now, to the establishment of the commissions of inquiry. As a starting point, a commission of inquiry can only be appointed by the president through a constitutional instrument in one of two ways, as spelled out under section 147 sub 1 of the 1991 Constitution. A. When the cabinet advised that it is in the public interest to do so, or when Parliament passed a resolution on its behalf to inquire into any matter of public importance. The three commissions of inquiry set up in 2018 on the 1st August by President Julius Maada Bio were a product of cabinet advice followed by the GTT report during that same period. Now, what did the cabinet advise that was of public interest, one may ask? The inquiry was explicitly stated in the GTT reports as part of its recommendation as an investigation into assets and other related matters of persons who were president, vice president, ministers of state and deputy ministers, and heads and chairmen of parastatals, departments and agencies within the period from November 2007 to April 2018. As the Attorney General and Minister of Justice stated at Special Court Complex, the commissions of inquiry looked at three key issues. 1. Governance processes, assets, and forensic audits. The forensic audits tracked fraudulent activities within entire chains of governance. The Commission on Assets examined disparities between income or means and assets. The Commission on Governance processes looked at inefficiencies, deficits in governance, especially where people deliberately misused or took advantage of state institutions. Now to the powers of commissions of inquiry. Now, pursuant to section 148 of the 1991 Constitution, the commissions of inquiry have the same powers, rights, and privileges of the High Court of Sierra Leone. In essence, the commissions of inquiry are equipped by law to exercise all functions of the High Court of Sierra Leone, including A. Enforcing the attendance of witnesses and examining them on oath or affirmation, B. Compelling the production of documents by witnesses, and C. To request to examine witnesses who are abroad. Now, the permanent mandate of every commission of inquiry are set out in section 149 of the 1991 Constitution. The commission of inquiry shall make a full, faithful, and impartial inquiry into any matters specified in the commission of appointment. B. Report in writing the result of the inquiry, and C. To furnish in the report the reasons leading to the conclusion arrived at or reported. These were the three stages the commissions went through to get to the point where we are right now. An inquiry has been conducted, whether full, faithful, or impartial, has been subject to a number of debates, which I'm constrained to comment on because this lesson is primarily legal analysis. Further, the result of the finding has been reduced to writing and was presented to the government months back. Finally, if you read the reports, the commissioner enunciated on the reasons for their conclusions in the report. Now, subsection 2 of section 149 provides that the president should cause the reports of the commission to be published together with a white paper within 6 months of the date of submission of the report by the commission. So the delay of the publication of the findings of the commission is evidently supported by law. I would also note that it is open to the president not to publish the reports. However, where that is the case, the president shall issue a statement to that effect, giving the reasons why the reports is not published. And finally, the right of appeal. Now, from the reports of the Commission, a substantial number of people who served between the period of 2007 to 2018 were seriously implicated on issues ranging from misappropriation, mismanagement, illegally obtained assets, and many more. Notable figures among those implicated were the former President Dr. Anesbai Koroma, former Minister of Youths, former Minister of Foreign Affairs and flag bearer of the APC, and many more. Subsection 4, Section 149 states that where a commission of inquiry makes an adverse finding against any person which may result in a penalty, forfeiture, or loss of status, the report of the commissions of inquiry shall be deemed a judgment of the High Court of Justice, and accordingly an appeal shall lie as of right from the commission to the Court of Appeal. In simple terms, the findings of the commissions are not conclusive or definitive. Persons named and implicated and who may have lost something as a result of the findings, either economic loss or a loss based on social status, can appeal against the decisions of the commissions. The appeal is of right open to every person so named and implicated in the reports, and can therefore be exercised at any time. I want to thank you all for listening. I have taken you through the establishment of the various commissions of inquiry as provided for by law, and I've also taken you through the findings, brief findings of the commission and the history behind that, and I've also taken you through the way forward, that is the right of appeal after an adverse finding have been made against certain people named and implicated in the commission, followed by a white paper that was released on the 24th September 2020. Thank you. Don't forget to subscribe, comment, like, as more contents will be coming up in subsequent